submitted, titled Food and Genocide, the Interplay of Zionist Ideology and Israel's Prolonged War. We would very much welcome your feedback and thoughts, of course. And in our paper, we examine Israel's war tactics against Palestinians, specifically the use of mass starvation consideration two primary legal frameworks, acknowledging both their significance but also their limitation in the plight of the Palestinian people for liberation from colonial domination and in safeguarding its existence as a people. The first is the legal framework surrounding the right to self-determination, especially as it pertains to the Palestinian people and its link to the right to food and food sovereignty under international law, but also in practice, in the reality of the Palestinian people today. And the second, which I will be focused on, is the genocide framework, specifically the Genocide Convention, which asserts that mass starvation and famine are central to Israel's genocidal actions. And of course, to be able to thoroughly examine all of this, mass starvation cannot be analyzed in isolation. It must be examined alongside other actions and patterns of conduct by the Israeli military and government, which further exacerbate harm and impact. Analyzing the interconnections among various actions and policies of the Israeli military in Gaza, especially over the past year, is essential to addressing the question of intent as well. This is in turn crucial for proving genocide, moving beyond written policies or plans to consider also organized, repeated patterns of conduct, circumstantial evidence, and awareness of the act's ramifications. These actions include repeated forced mass displacement of the Gazan population amid ongoing air, land, and sea bombardment, the near total destruction of essential infrastructure for human life, and simultaneous prohibitions, restrictions, and targeting of humanitarian aid and food sources. And just to go over quickly the actions that Israel has taken over the past year to dismantle food systems and sovereignty in the Gaza Strip. As part of its genocide and intensified aggression against Palestinians, Israel conducted a mass starvation campaign. It has reached beyond catastrophic levels, particularly across the northern parts of the Gaza Strip in the past month, severely exacerbating Israeli-created and internationally sanctioned humanitarian crisis. And generally, starvation tactics include blockades, water deprivation, destruction of food systems, and widespread damage to civilian infrastructure, which often result in forced displacement. And in perpetrating its current genocide, Israel systematically destroyed food sources within Gaza, and the destruction has targeted agricultural lands, fields, greenhouses, orchards, and irrigation systems, as well as key infrastructure such as flour mills, bakeries across the Strip. Additionally, we've seen Israel escalate its targeting of Palestinian fishermen, which has resulted in near total devastation of Gaza's fishing industry, which is a critical food source for the population. And by doing that, Israel has in effect destroyed and blocked all possible access to food within Gaza for its 2.3 million inhabitants, nearly half of whom are children, the group that is most vulnerable to malnutrition, starvation, and disease. And the population has been forced to almost entirely rely on food coming from outside of the Gaza Strip, which is subject to Israeli-controlled military checkpoints, arbitrary and inhumane restrictions and delays. That is, if it's allowed entry at all and distribution. And this is, of course, these like these measures and policies and practices that we've seen over the past year. They're part and parcel of Israel's prolonged closure, blockade, and isolation of the Gaza Strip over the past decades. So the restrictions that Israel has imposed on movement and goods between Gaza and the rest of Palestine, isolating Gaza by limiting imports, exports, and the freedom of movement since its military occupation in 1967, has been integral to the fragmentation of Palestinians, which is central to the Zionist settler colonial project. And more specifically, from the early 90s through 2000s, these restrictions intensified over Gaza, often involving total closures. Probably the longest of these closures has extended between 2000 until 2023, right before or preceding the total siege that was imposed in October 2023. And throughout, Israel has systematically targeted and destroyed agricultural lands by bombing and bulldozing fields, spraying chemicals from air and land to destroy crops within the so-called buffer zone, uprooted trees, and restricted farmers and herders from access to their land. Again, we've seen over these decades that the military has also consistently targeted and prohibited the access of fishermen to the sea, which is a vital source of food. And in 2000, between 2007 and 2010, we've seen Israel's publicly acknowledged policy, which was to allow only enough goods into Gaza to keep people hungry, but not enough to spark a full humanitarian crisis. The Israeli Ministry of Health even calculated the calorie requirements based on the age and gender to determine the quantity and type of food permitted entry, allowing only the daily humanitarian portion of food and medicine. And even within this limited framework, Israel had often failed to meet its own guidelines, allowing only a fraction of the estimated necessary aid and restricting specific foods. So what I'm trying to say is that as a result of Israel's decades-long restrictions and military offensives in Gaza, over 53% of the population was food insecure, with more than 80% dependent on humanitarian aid before the current genocide. So Gaza's food insecurity and food domination did not begin in October 2023. The rapid onset of starvation and famine following the total siege that Israel imposed that October is evidence of Gaza's complete lack of food sovereignty, which is a condition similarly faced by Palestinians across the entirety of Palestine. And here it is important to note that while this paper focuses on the Gaza Strip, it also considers Israel's accelerated persecution of Palestinians throughout the rest of Palestine, including in the West Bank and Jerusalem, which has directly and indirectly compromised Palestinian food sovereignty and access. For example, through the accelerated land takeovers that we've seen in 2023, which has led to the displacement of entire herder, farmer, and Bedouin communities across the West Bank. And such land conquests mean the subjugation of Palestinians by disrupting their means of subsistence and livelihood. And over the years, we've seen how Israel has seized, dominated land, exploited its resources, many times to the point of depletion, reducing the native population to near total dependency on Israel itself, as well as on humanitarian aid and charity. And other measures have enabled Israel to capture and to dismantle the Palestinian food system, thereby eroding Palestinian food sovereignty and the right to food. And the paper looks into the reasoning and the impact behind the starvation campaign that Israel has carried out as part of its genocidal violence in the Gaza Strip. Specifically, it looks at, it tries to make the link in the context of how Israel's starvation is part of its logic and structure of elimination of Palestinians, and the impact, of course, that we see in the compounded suffering, especially among children, pregnant and breastfeeding women, the elderly, and those with existing health conditions, from severe malnutrition and dehydration to diseases to the extent of death. And it's important that the paper underlines that as with genocide, famine unfolds as a process, meaning that even if a ceasefire were reached and the siege is lifted, hunger and its individual family and societal scars would continue to persist because famine has long-term impacts. It inflicts serious physical and mental harm on those who survive it and results in harm to health and social trauma that can go on for generations. And there has been some recognition, in addition, of course, to the documentation and warnings from Palestinians themselves and Palestinian civil society about starvation and famine as genocidal acts. There has been some international recognition that has underscored this classification. For example, in July 2024, the UN experts declared that famine had spread across Gaza and identified it as a form of genocidal violence. The International Court of Justice provisional measures orders in the case of South Africa versus Israel, especially the orders of March and May, emphasized that Israel's starvation of Palestinians in Gaza constituted a possible breach of the Genocide Convention and therefore may amount to genocide. We didn't see the same, unfortunately, with the ICC prosecutors' classification of starvation as a war crime, completely sidelining Israel's broader campaigns of extermination and destruction in Gaza. And the last point that I want to raise is, does it really matter if starvation and famine are recognized as acts of genocide? And in all honesty, at this point, I don't know if it does matter or not in changing the reality, but I'm leaning towards more of a yes, it matters, because settler colonies and settlers have historically used starvation and famine as a tool of conquest, subjugation, and genocide. And I think such recognition is important to acknowledging the structural nature of the Zionist Israeli settler colonial domination and elimination, especially at a moment when it is on trial for genocide at the ICJ, and which has relied on various tools and methods over time to achieve its objectives, such as food domination and mass starvation. The recognition of such classification may also be important for purposes of prevention, accountability, and justice, to advancing the genocide legal framework under international law, moving it to align more closely within its foundational principles, including with Lemkin's aim to recognize starvation as a deliberate tool for genocide, which states deliberately excluded from the international definition of genocide. But in any case, today the legal debate does not really matter much. What matters is bringing the mass starvation, the extermination, and the destruction of Palestinian life to an end. I will stop here and pass it on to Tommaso to share his reflections as well. Thank you.
Thank you very much. What I'd like to suggest is that we have all three presentations, and then we open the floor up to questions and conversation. So with that, our second paper and speaker comes from Gentiane Zaberi, and the paper is entitled Using the Permanent International Courts and the Main International Human Rights Treaty Bodies to Claim the Inalienable Rights of the Palestinian People. Gentiane Zaberi is Professor of International Law and Human Rights at the Norwegian Center for Human Rights, Faculty of Law, University of Oslo. He's been a member of the UN Human Rights Committee from 2019 to 2022, and is currently a member of the Permanent Court of Arbitration at The Hague from 2016, and his present term ends in 2028. His research includes the role of international courts and tribunals in developing international law, the protection of community interests in international law, and transitional justices, processes, especially in the Balkans. Welcome, Professor Zaberi, and we look forward to your paper. Over to you.
Thank you very much, Professor Badi, and I want to thank the Muvatin Institute for Democracy and Human Rights for the kind invitation, and my colleagues, Professor Mudar Kassis and Joyce Kashu, for the assistance with this. I hope you can see my slides. Basically, what I'm going to talk about this evening in the next 20 minutes, give or take, is how the Palestinian Authority has used the two permanent international courts, the International Court of Justice and the International Criminal Court, to increase the level of protection for the Palestinian people, to bring those claims at the international level. And I'm also going to mention a little bit the procedures, the interstate case between Palestine and Israel before the Committee on the Elimination of Racial Discrimination. So I think that international law has played an important role in the Israeli-Palestinian conflict for a very long time, and it has played probably an even more important role in the last 20 years or so. And there are many reasons why the state of Palestine resorted increasingly to international law, and I think probably there are three main reasons. One is the asymmetry of power. On the one hand, a state that is curtailed in what it can do because Israel occupies most of its territory. The second is using international law to draw more attention to the serious violations of international law. And the third, I think, is to ensure broad international support. Now, there are at least 5 cases before the International Court of Justice, 2 advisory opinions that have been rendered, and 3 contentious cases that are ongoing, one brought by Palestine itself, which relates to the movement of the US Embassy to Jerusalem, and the other 2 concerned the case brought by South Africa against Israel about the situation in Gaza, and the other one was brought by Nicaragua against concerned occupied Palestinian territory. I will also try to address the procedures before the International Criminal Court and give a little bit of the background. And also, I think it's important to highlight some of the double standards that have been following the Palestine situation before the ICC. What are the issues that have been raised? I think that's relate very much and reflect the situation in Palestine, the prolonged military occupation and the legal consequences of the right to self-determination. That is 2 important issues for the ICJ, and international crimes committed before the ICC. war crimes, crimes against humanity, and in fact, genocide. Now we have probably persons that are not maybe well versed in the Palestinian-Israeli conflict. They might be following this on YouTube. I'm not going to give here a full historical account of the conflict, but it is important
عن هذا النزاع، لكن من المهم جدا أن نعرف بأن كان هناك جهود دولية قدمت لحل هذا النزاع، لكن في العقد الأخير أو أكثر من ذلك كانت عملية السلام هي من إسرائيل للدخول، وكانت هناك كثير من التطورات خصوصا خلال إدارة ترامب عندما نقل سفارة إلى القدس، باعتبار أن القدس كما ذكر هي عاصمة إسرائيل. عندما نتحدث على تدخل السلطة
just that we can distinguish one starting in 1989 with the efforts by Palestine to join UNESCO, World Health Organization, which were vehemently opposed by the US, threatening basically to pull the plug on these institutions. And then more successful efforts from 2009 onwards, with the Palestine joining a lot of the human rights treaties, main core UN human rights treaties, but also a lot of international organizations and its strengthening of its status at the United Nations. I put this here as well, maybe for a very simple reason, that to see what has happened over time from the UN partition plan in 1947, with an allocation of territory, let's say about 45 to 55, 45 for Palestinians, to Trump's peace plan whereby that territory is reduced to only 15% of historic Palestine. I think that's also part of why I think the situation with annexation of territory that has continued over time has also pushed the Palestinian Authority to take these steps. With regard to Palestine and the ICC, if you look at the Palestine situation at the ICC, it seems like everything started in 2015, but that is not the case, because the Palestinian Authority and the Palestinian Center for Human Rights tried to bring these issues before that to the attention of the ICC already in 2009, and the first ICC prosecutor rejected these efforts in April 2013, so almost 3 years later, with I think a 2-3 page document that was heavily criticized by many international criminal law scholars. But Palestine didn't give up, so it became a state party to the ICC in 2015. And then, despite the fact that the situation in Palestine has been closely followed, the crimes have been well documented, at least since 2008, but even earlier, it took 4.5 years after Palestine became an ICC member state for the second ICC prosecutor to announce that the statutory criteria for the open investigation had been met. And then 2021, the prosecutor announced the opening of the investigation, the situation in the state of Palestine, which actually the investigation of Afghanistan and also of the situation in Palestine resulted in the high officials of the ICC to be sanctioned by the US. So just to sum up a little bit this history of delays, if I can call it that, the Palestine situation has been pending before the ICC for over 15 years, if we take into account here also the propriemotive powers of the Office of the Prosecutor. And then finally, the third ICC prosecutor filed applications for warrants of arrest for 3 high officials of Hamas and for 2 high officials from Israel, Netanyahu and Gallant, and more than 5 months later, there are no arrest warrants issued yet. And if I compare this with the situation in Ukraine, it took about 3 months for the arrest warrants against the Russian president to be acknowledged and by the pretrial chamber. And overall, I think an average, if I'm not mistaken here, that has been, by looking at all of these procedures, is that it hasn't taken more than about a month and a half for these arrest warrants to be issued, generally. Something else that also we should draw attention to in terms of who is supporting and then the division, if you want, between the global north and the global south in terms of support. We have a number of countries referring the situation to the ICC. Legally, it doesn't necessarily mean so much because the situation is before the ICC, but I think it matters when one thinks a little bit more about the signals that this sends to the court, operating on a zero growth budget and having so many situations before it where to spend that money. So I think that is quite problematic. Then we also know about the intense pressure on the ICC to drop the investigations on the Palestine situation, especially by the US authorities, the interference, pressure by Israeli authorities. So this is quite problematic, I think, in terms of if one thinks about the ICC being there to investigate and prosecute mass atrocity crimes wherever they are committed, when it concerns persons that have the citizenship, the nationality of the ICC state parties, this is quite problematic. And also very problematic is that there's still no access to Gaza for the ICC. I think I'll skip this, but just to note that a lot of persons, when they speak about Gaza, it seems that their clock starts from the 7th of October, 2023, which indeed was a tragic event with brutal attacks, which resulted in the killing of about 1,200 Israelis. But if we just look here at the numbers and the situation, we have armed conflicts there in 2008, 2009, 2012, 2014, 2018, 2019, 2021, and then now more recently. And if you just look at the numbers of the persons killed here, I think it is quite clear that there is no sense of proportionality in the military operations carried out by the IDF. And now we're moving over 43,000 Palestinians killed and over 100,000 injured. And a lot of these individuals are women and children. And I have to make another note here that the fact that the rest is men doesn't make them military targets, or also doesn't mean that they are lawful targets. So now moving on to the ICJ, trying to keep an eye on the time, but I hope you can give me a little nod. 5 recent cases from 2003 to now, so it's a span of about 2 decades. Lots of cases. I think probably there hasn't been any other situation that has attracted so many or has so many cases brought before the ICJ, because we don't have only these 5 cases, but we also have 2 related historical advisory opinions which relate actually to the situation in Palestine. We see here that many states have participated in these advisory opinions. As you can see here in the numbers, we have 40, 50 states that have participated. We have the EU participation in the first advisory opinion of 2004, no EU participation in 2024. But I think here we have to note the states that supported Palestine in pointing out the unlawful policies of annexation, illegal settlements, violations of civil and political rights, economic, social, and cultural rights of Palestinians, because the wall and the associated regime and the prolonged Israeli occupation, 57 years at least. But what should be noted as well is that a number of states, especially from the global south, they were trying to push Palestine on these matters, and they were trying to push the court to saying that these procedures before the ICJ are not going to help the peace process. And while probably in the first advisory opinion, there might have been some semblance of a peace process ongoing, the second time there was nothing actually along those lines. So this was a very problematic position to take by many countries. If we look at the South Africa versus Israel again, and to compare with another genocide case, or the two other genocide cases, we see here that we have 10 states that are joining here, the case South Africa versus Israel, and with the exception of Spain, we have no other EU countries, whereas the case brought by Ukraine versus the Russian Federation, there we have a long list of states from the EU and NATO joining. Again, quite a clear problematic position, I think, on the part of those countries. Finally, before I move on to obligations for third states that have been taken up by both advisory opinions, when Nicaragua brought the case against Germany, I think probably there was some derision by the part of some countries trying to speak about Nicaragua's own human rights record in order to, if you want, cast some shadows on the the position of Nicaragua to bring a case against Germany. But that bringing of the case resulted, at least initially, in Germany taking some steps to limit the military aid given to Israel, although that seems to be moving a little bit back and forth. Something to point out on both advisory opinions is that judges have been quite the overwhelming majority of the judges have stated very clearly that the wall and associated regime is contrary to international law. Israel should dismantle it, the wall and the structure and the associated regime, make reparations for all damage that has been caused, for all the states not to recognize the legal situation, not to render aid or assistance, and for ensuring compliance by Israel with IHL as embodied in the Geneva Convention 4. I have to say here that there has been enough condemnations, but no sanctions against Israel by the US, EU, and individual countries. So that has been quite problematic. And the advisory opinion of July 2024, again, addressed to Israel, all states, international organizations, and especially the UN and the General Assembly, which has been followed up by the General Assembly resolution in September. It's quite important because it speaks, or it outlines a little bit in more detail these obligations. And the most important part here is that it asks Israel to bring its unlawful presence in occupied Palestinian territory to an end as rapidly as possible, with the General Assembly saying that that has to be within 1 year. So to conclude, very quickly, international law is very important, although I think it's a bit difficult to be too upbeat about international law when we see the situation and the flagrant breaches by Israel and the lack of real sanctions on the part of states. But also, I think we have to see that the situation is changing with a number of countries, with Spain, Ireland, Belgium, Norway, other countries taking concrete steps to try to put more pressure on Israel, including through potential sanctions and in any event, trying to stop or not to provide support for the maintenance of this situation. Palestine has tried to use international law to bolster its claim, also due to the asymmetry of power. International law can serve as guidance to resolve or to bring about a just solution to the long conflict. And also the ICC will play an important role to ensure individual criminal responsibility despite the delays. I think there are three immediate imperatives regarding Palestine: ceasefire and humanitarian assistance to Gaza, the release of Israeli hostages and arbitrarily detained Palestinians, and the end of the Israeli occupation and respect for self-determination of the Palestinian people. And I think here all of these advisory opinions and the cases before the ICJ and the ICC are going to play an important role. Thank you. I'll stop here.
Thank you very much, Professor. And we continue with our discussion of international law with our final paper entitled International Law and Divestment Strategies, Counter-Hegemonic Leveraging of Legal Frameworks to Counter Occupation and Erasure of Palestinian Identity. And it's my pleasure to present the speakers for this part of our panel. Our own University of Windsor student and fellow at the Transnational Racial Justice Network at the University of Windsor, Nadine Al-Tahir. Welcome, Nadine. And my colleague, Professor Vasanthi Venkatesh, whose work focuses on law, land, and local economies, in particular, labor, migration, immigration, and citizenship law, as well as social movements, racialization, and discrimination. And she uses an interdisciplinary approach to her research and utilizes both quantitative and qualitative research methods to examine how power and privilege are constructed in the legal system and how global phenomena impact local realities. I could go on. She has a very long and impressive bio, but I think let's use the time to hear from both Vasanthi and Nadine. So over to the two of you.
In international law. The Unified Palestinian Call for BDS by the Palestinian Campaign for the Academic and Cultural Boycott of Israel, PACB, demands that the tactics of BDS be used to shame and force Israel to meet its obligations to recognize the Palestinian people's inalienable right to self-determination and to fully comply with international law. by ending its occupation and colonization of all Arab lands and dismantling the wall, recognizing the fundamental rights of Arab Palestinian citizens of Israel to full equality, and promoting the rights of Palestinian refugees to return, as stipulated in UN Resolution 194. The inherent contradictions that arise from using the master's tool, the liberal legal system that underpins the occupation of Palestine and oppresses their resistance, but also the capitalist tactics like consumer boycotts and socially responsible investing, which are also integral to Zionist strategies, have been discussed before. However, these contradictions have never felt more pronounced than they are today, in light of the relentless Israeli violence that is perpetrating an ongoing genocide and regional war. This is compounded by the dehumanization of Palestinians and Arabs, alongside the active involvement of US, Canada, and Europe in military operations, as well as the suppression of pro-Palestinian resistance within their borders. As Faisal Kuti said in a recent article, Gaza has become the graveyard of liberalism, including its human rights system. He quotes an anonymous commentator who stated, "People think Gaza is occupied, but in reality, Gaza is free, but the whole world is occupied." So what does this mean for the BDS movement? There is a wealth of scholarship employing a Gramscian perspective to highlight the movement's potential to challenge and disrupt Zionism and Israel's dominance in ideological and discursive arenas. For instance, in the anti-racism discourse, allegations of anti-Semitism are often used to silence discussions about Islamophobia and other forms of racial prejudice. Similarly, in narratives surrounding the rule of law and democracy, Israel is portrayed as a liberal stronghold amid illiberal threats. BDS disrupts these spaces by showing how Israel fails the standards of even a reasonable liberal state through its grave human rights violations. However, using the tools of liberal law to counter-hegemonize liberal spaces has its limits. It can't even stop a genocide. So in our presentation today, we draw on the framework of Fanonian resistance presented by the martyred Palestinian writer and teacher Bassel al-Araj through his essay, "Live Like a Porcupine, Fight Like a Flea," to describe and contextualize the movement in University of Windsor as a counter-hegemony through decolonial anti-imperialist radical tactics, which also challenges the master's tools of international law.
Can I just, sorry to interrupt you, Professor Venkatesh, can I just ask everybody to slow down just a little bit for our translation?
Thank you so much. We appreciate it.
Hello. So as Al-Araj describes it, the Palestinian resistance lives like porcupines. They are night animals with a high sense of security that live underground in large holes connected to a network of tunnels. Its pain is deep, but its grudge is even deeper. And when threatened, it wails and attacks with spikes. The flea, however, fights by exhausting and demoralizing its host, by annoying, sucking its blood, and not allowing it to rest. And living like a porcupine. So throughout the journey, our encampment was designated as the Liberation Zone. This was a deliberate use of liberatory anti-colonial discourse, a strategic initiative to create a decolonial space by disrupting the entrenched hegemonic environment of the university, where we are cast as the threats. Within this space, we had only a few tents, far fewer than in UFT and Columbia University encampments. As such, only a humble number of us were present, while others rested like porcupines at night. We organized workshops, education circles, and discussions to learn how to adapt tactics from these resistance movements. Our approach was informed by deep community engagement, fostering connections and educating others about Palestine through a radical resistance lens. This disruption of hegemonic space required a concerted effort to challenge and dismantle the pervasive structures of Western hyper-individualism, capitalism, and white supremacy, which we identified as foundational to Israeli exceptionalism and occupation. Despite our smaller numbers, though our broader community in Windsor was large, the university recognized us as sufficiently prickly enough and restless enough to engage with. So after 62 days of this on-the-ground disruption, the signing of our agreement took place in the President's Building, an emblematic site of colonial power, both administratively and also due to its proximity to the colonial American border state. The building faces the American border. The location's significance illuminated the importance of entering the space with the memory and spirit of the shuhada, the martyrs, embedded in our hearts, minds, and spirits. Here is a photograph of us the day we were signing the agreement. So, as you can see, I wore a traditional thobe purchased in Ramallah, featuring the colors of the Palestinian flag. This hand-embroidered garment, reminiscent of the infamous Intifada dress, serves as a powerful symbol of resistance within this moment. Secondly, the kufi is demonstrated in this photo, which is another significant emblem of Palestinian identity. This was also noteworthy given the rise of anti-Palestinian racism that has been barring individuals from wearing kufiyas and entering buildings as a result.
Nadine, we need to slow down. Sorry.
Oh, okay. Over here, I wore the kufiya as a headscarf, drawing inspiration from previous legendary figures in the resistance movement. Number 3, before signing the agreement, we collectively engaged in prayer, reading Surah Al-Fatiha, Surah Al-Tin, and Surah Al-Nasr. We grounded ourselves and our commitment in spirituality before formalizing this agreement. What's interesting here is we did not request for some time to engage in prayer. In fact, we demanded it by naturally performing it. This was critical given the Islamophobic tropes, a fundamentalist terror associated with Muslim praying. And lastly, the prominent display of the Palestinian flag in the bottom right corner was a defiant gesture. It reflected our indomitable spirit and refusal to allow it to be hidden. This flag, sourced from Palestine, symbolized our unwavering commitment to the Palestinian cause. So, our demands and actions were prefigurative of a politics on decolonization and liberation. We were steadfast in our refusal to allow any erasure of explicit mentions of genocide, occupation, and Palestine itself. The agreement begins with an explicit
وبدأ ذلك بمطالبة وأفعال سياسية وكان العرض يعني واضحا بادعاء عدم السامية وما إلى ذلك. وطبعا هذا أيضا كان أن يكون هناك تحقيق المصير وبناء علاقات مع جامعات فلسطين وجامعة بيرزات، مع الإشارة صراحة إلى قتل العلماء في غزة. وعلى الرغم من أن الإعلان الختامي بدأ بإدانة عامة لجميع الانتهاكات حقوق الإنسان الأساسية حيثما قد تحدث.
And then the next item we have is item number 4G3.
رقم G3 مع أن الإعلان الختامي يبدأ بإدانة عامة لجميع انتهاكات حقوق الإنسان الأساسية حيثما قد تحدث، إلا أنه يتضمن إشارة صريحة إلى إنهاء الاستعمار، حقوق الإنسان، العدالة الاجتماعية ومكافحة العنصرية في سياق احتلال فلسطين وتدمير غزة من قبل إسرائيل. مثل البراغيث استنفذنا الإدارة في تسمية إسرائيل كالجهة المعتدية. إذن أحد الجوانب المحورية لهذا الاتفاق هو تنفيذ مقاطعة أكاديمية ضد الجامعة الإسرائيلية، والتي تقولها اللغة بأنها ستظل سارية حتى يتحقق حق تقرير المصير الفلسطيني كما حددته الأمم المتحدة. ومن غير المستغرب أن تلقى هذه الفقرة أكبر قدر من ردود الفعل العنيفة، والتي تركزت في المقام الأول على الحجج الشائعة حول الحرية الأكاديمية وحياد الجامعات. ومع ذلك قد تم تفنيد هذه الحجج تماما، وخاصة في ضوء الإبادة الجماعية، كما ذكر نعم تشومسكي عن حجة البيت الزجاجي الشهيرة هذه، مؤكدا أن الأوساط الأكاديمية الأمريكية والأوروبية والكندية متشابكة بعمق مع مجمع الصناعي العسكري والكيانات الأخرى المسؤولة بشكل مباشر عن إفلات إسرائيل من العقاب وأفعالها القمعية. وتساءل الغربية الهيمنة الأمريكية والغربية.
Can I just
ولهذا
interrupt for just a second? I am so
نجيب.
sorry. It seems some of us are having technical difficulties and we can hear only the translation, but not the speakers. I wonder if there's a fix for that.
There is. I've just switched.
Perfect. Okay, we're good to go again. Thank you so much. And my apologies for the interruption.
Thank you. For this, our answer is that challenging Zionism and US imperialism are not mutually exclusive. The focus of the agreement was and is Israel's aggression and opposing Zionism. As Sarah McMahon has said, what matters is not the presence of contradictions, which are inevitable given our positionality in the enabler's territory. But did we challenge deeply entrenched and heavily policed boundaries of the discourse of Palestinian-Israeli politics? In fact, by refusing to engage in liberal or left whataboutery by mentioning other countries, the agreement has pushed the most heavily policed boundary in academia with the boycott clause. Ironically, even the use of international law in the boycott clause, self-determination, but as determined by the United Nations, works in this case as it centers the dysfunctionality of the UN in recognizing Palestine self-determination. The limitations of BDS stemming from its juridical international law nature is most apparent in the divestment component. The university committed to ethical investment practices and is revising its responsible investment policies, but which is based on the UN's environmental, social, and governance, or ESG principles, to explicitly incorporate international and domestic law. But it refused to endorse an arms embargo. There is already extensive scholarship critiquing the self-regulation-based UN mechanism, labeling it as cuddly capitalism or greenwashing that merely diverts capital flows rather than achieving true divestment. It prioritizes capitalist interests over social values, ultimately perpetuating the logics of financialization and commodification of justice and rights. Nowhere is this more apparent than in the weapons industry investments. In light of international law around just war and the right to self-defense invoked by Ukraine and Israel, weapons and associated multi-use technologies, such as AI surveillance systems and drones, are now framed as enhancing democracy, territorial integrity, and human rights. Tech companies such as Google and Microsoft have integrated themselves so deeply into our lives that divesting from them has become virtually impossible, regardless of what they do. Additionally, regarding Palestine, the prevailing compromise is to restrict divestment to companies listed in the UN Human Rights Council database that are involved in settlements in the UN-defined occupied territories, primarily the West Bank, effectively shielding other Israeli companies from scrutiny. So participants in the movement at UWindsor had to grapple with these contradictions. Much of it is created by international law, while also challenging the administrative power structures. Although the movement succeeded in not confining scrutiny of companies only to the liberal international law. Like fleas targeting the most vulnerable parts of its host, the movement was able to expose the substantial threat that financial and economic dimensions of liberation pose to the very structures of the global order established by the West. But it also shows the importance of having new tactics to bring down what John Ikenberry has called the liberal Leviathan, the American international political order.
So now we will look at what it means for resistance and liberation of Palestine. Bassel al-Araj emphasized the importance of integrating armed struggle with the boycott movement, blending legal, economic, and grassroots strategies. However, he cautioned against an over-reliance on international law. He viewed it as a tool historically designed for the colonizer and often deployed for the normalization of hegemony. In his essay, Out of the Law and Into the Revolution, Al-Araj stressed the need to transcend legal structures. The BDS movement adopted its tactics in the 2000s to challenge Israel's narrative of exceptionalism, which is based on its claim to be a homeland for Jewish exiles and its self-presentation as the only modern democracy in the region. The campaign's universalist conception of rights recast Israel as a state like any other, with the same obligations and responsibilities that it has ceaselessly violated, which was crucial. However, despite the ongoing genocide broadcasted to the entire world, numerous ICJ rulings against Israel, and unanimous condemnation from United Nations Special Rapporteurs, none of the efforts to name and shame through international legal institutions have succeeded in stopping or even moderating Israel's behaviors. As Rob Knox has stated, for many, Israel's actions may represent a perversion of international law. For example, the right of self-defense, which is supposed to be limited by necessity and proportionality. But he also pointed that this is international law, not a perversion. The position of a reasonable bourgeois state in international law, which is the standard that the BDS movement is holding Israel to, is an imperial one. And lastly, in Al-Araj's work, The Economy in the Intifada, Al-Araj presents a model of resistance that reinforces the importance of adaptability and diversity in resistance strategies amidst the time of the monsters. Through his work, we see that in their fear of dismantling existing structures, including international law, communities often end up de-radicalizing themselves as a form of self-sabotage in response to their inability to adapt tactics and strategies to changing circumstances. This rigidity and approach can lead individuals to feel disillusioned and hopeless, ultimately turning them into a liberalized adversary of the movement. This represents a significant threat to the national struggle against the prevailing global order and the pursuit of transformative abolition and change. As Knox noted, Ghazze urges us to examine the systems of exploitation and domination that shape our contemporary world, as these dynamics are the key to understanding the violence and the occupation, rather than international law. Consequently, we must adjust our tactics to dismantle these relations of domination. Through his metaphor of the porcupine and the flea, Al-A'raj's counter-hegemonic resistance asks for a symbiotic, multifaceted, adaptive approach with community empowerment, liberatory praxis, and the continuous evolution of defense mechanisms. As such, we must understand and accept what the revolution requires from us from different points of time, even if it means throwing an expo marker or a stick on a drone. This nuanced understanding is crucial for sustaining the integrity and the effectiveness of the resistance movement, ensuring it remains a powerful force against colonial imperialism and in pursuit of Palestinian liberation and the downfall of the current cancerous hegemonic structure. Thank you.
Thank you very much to all of our speakers. We have a little bit of time for some questions and conversations. So I'd like to ask those who are online and would like to ask a question to please put up your hand, and hopefully I can see it, and we'll start the conversation with those present. I see Thalia Kruger.
Yes, hello. Thank you very much. Can you hear me?
Yes.
Thank you very much for those presentations. I had a question to the last speakers, and that is when you refer to the BDS, you spoke specifically about divestment, but I was wondering what the university has done with, well, whether there were research cooperations with Israeli universities and how you approached those, or how, not you, but your university.
You want me to? No, the agreement imposes a boycott on agreements with Israeli universities. Now, incidentally, the University of Windsor does not have any such agreements. So that worked in our favor. It's also not a Harvard or a Columbia University, which is deeply entrenched. And this is where Chomsky was referring to, is that Harvard is as complicit or Columbia is as complicit in the occupation as the Israeli universities, including its persecution of Palestinian students within. So yeah, so there is a boycott, but at the very, I think it's the fact that there has been so much backlash against it shows that it still is meaningful, even though there are not that many agreements to cancel.
Thank you. I think as people formulate their questions, I don't see any other. Maybe I could ask the panelists. Oh, actually, I will defer to Gentian Ziberi. I think you have a question.
Thank you. Probably not as much a question as a little comment, actually, to the last presentation. And I think it has been excellent that students and academic staff have really put pressure on universities to change their old ways, to divest from arms producers, to ensure that there is no institutional cooperation with Israeli higher education institutions for as long as Gaza's higher education institutions have been completely obliterated, and the rest of Palestinian universities is under the occupation regime, in a sense, with all the restrictions. But one, in terms of international law, not to be the advocate of international law here, but to me, it seems it's not the matter that international law is necessarily so inadequate, because when it comes to sanctions against another country, we see that we have a lot of sanctions, for example, against the Russian Federation, right? So international law was not a problem to impose broad sanctions, economic sanctions, political sanctions, and so on. But we see a huge reluctance after almost 6 decades of Israeli occupation of Palestinian territory to impose any meaningful sanctions on Israeli institutions and the Israeli state. So just to say that, and in my view, and I would like to hear your views on that, in my view, those most recent developments, the pressure on the part of the students and the attention, students' academic staff, I have to say, and the ICJ advisory opinion of 2024, UN General Assembly resolution now more recently about obligations of third states, the inquiry commission's latest report, I think it's dated 18th of October in terms of obligations of states, including concerning in the field of education. All of this is going to, I hope, going to lead to a change of position. Now, we see that there is a change of position in a number of states, but not as fast as we would like to. So I'm just wondering if you have any further reflections on this. Thanks.
And can I actually throw that question out to the remaining 4 participants, not just the last panel, but please let's start with Vasanti and Nadine. Thank you very much for the question.
Yeah, thank you for the question. In terms of international law, Bassel al-Arash, although he values international law and its use, we need to continuously recognize that this system was not created for the advancement of the racialized, marginalized people. So when we see the quick answers of international law towards situations in countries like Russia, of the Ukrainian issue, we see how fast they were able to act. But when it comes to situations of Palestine or racialized bodies across the globe, we see that international law either finds itself as very slow in operation or completely ineffective and null in operation. Or it keeps tiptoeing around the idea of having the racialized people to continuously prove their oppression, occupation, and disadvantages. So with that being said, international law assisted us within the building of the agreement in terms of finding wording. However, we did have to be a bit conscious about how much we wanted to rely on international law, which is why we added subclauses of considering domestic law as well, within considering divestment strategies and divesting from companies and not participating or being complicit in genocide. But if Dr. Venkatesh has any extra thoughts, feel free to go ahead.
I think, Nadine, you captured that really well. And, Professor Zuberi knows better with his description of the ICC. We know who the ICC has gone the most after. The number of African persecutions that the ICC has done in comparison to others. So there is ultimately, if you think about the more critical analysis of international law, the unfortunate conclusion is that it does favor the power, and how much it favors the weak is how much it has favored those who have been colonized before, and so on, remains it's a big question to have. But I think Nadine captured the position quite well.
Thank you. Our other panelists, Mahad, Tomoso, do you have thoughts you'd like to share on that point?
Perhaps just to complement what Nadine and Vasanti have already mentioned about, we can debate and discuss the limitation and shortcoming of international law from its foundation to its lack of enforcement, to its own double standards, its mechanisms and institutions' own double standards, and involvement in the colonization of Palestine, in the entrenchment of the domination, and leading us today to a point of genocide. But at the same time, I think there are, as Chantian said, maybe some opportunities coming from the ICJ's advisory opinion, the following General Assembly. But to what extent these will be enforced. I think we have every right and reason to continue to be skeptical about the international community's seriousness in addressing historical injustices for Palestinians. And today, I think the reaction of the international community to Israel's parliament's banning of UNRWA and its operations in Palestine on both sides of the Green Line, I think this reaction should also give us a very clear indicator on where the international community is headed, whether it will continue to put some faith in international law and implement it or not. And if the reaction falls short of unseating Israel from the UN General Assembly, then I think the answer is very clear to us as Palestinians. And this is where the relevance of the last presentation comes into play, that we need to look for other complementary frameworks and tools that will help us in achieving what we want: freedom, justice, dignity, and so on.
And also very briefly on my side, I definitely have very little to add, but I think that a whole system that we hope is going to be doing something is probably not a system we should be upholding. So this idea that we look at international law with the hope that we will do one day something different, I think says a lot about the way in which the system is functioning. And maybe what has been happening and what has been done by international law is because people have been mobilizing, because people have been doing things that international law doesn't really prescribe, and international law is not really calling for. So I think that's a debate where I stand. But I also would like to bring in the experience of the University of Antwerp, where like similar debates and discussions have been happening. And to one extent, we could say, well, international law and the advisory opinion of the ICJ actually mattered to call for a reconsideration of some of the partnerships. But even when the ICJ issued the advisory opinion and issued the preliminary measures, and then again another intervention of the ICJ, and then again the ACC, even all of that compiled didn't really lead to a radical change in the position that the university adopted. Because if you play the card of international law and interpretation of clauses and articles, you will always find someone who's going to be proposing an interpretation that aligns with their own understanding of what proportional is or relevant is, or what international law says, to the point that we had at a certain moment a whole group of international law experts presenting a statement and a position vis-a-vis the partnership with one Israeli university, and then the rector presenting their own interpretation of that partnership, and then calling for a sort of assessment of legally speaking, who is right and who is wrong. So that's what international law and law in general are allowed to do, that there are always going to be arguments that you can use in order to present your case, and then you kind of equate the sufferance of one Palestinian with the sufferance of the oppressor. And I think that that's not a game that we should be playing. And if we play by the rules of international law and law in general, I think that's what we are opening up to, the possibility of really getting very nasty interpretation of the same arguments that we want to make, and then finding ourselves with no option to move forward.
Thank you. I see Mudar's hand up. Mudar.
Thank you, Reem. Well, if you allow me, I would first like to mention that there was Professor Koen de Veter was supposed to be on this panel. He passed away untimely, etc. He was the Dean of Law at Antwerp, and he led a partnership with the Muwatin Institute. My question is more of a contemplation that I would like to address first to Gentian, but actually to all panelists and even the chair. And when I hear throughout the panel, I was hearing like there are two levels of the questions that we are dealing with. One is jurisprudential, if you wish, what international law is meant to be, how it was designed, etc. And there's probably a problem there. It was designed as, as an elitist tool, if you wish, and probably even a separatist one in a sense, etc. But the main problem that we face right now, we're talking more about, is how this jurisprudence is implemented. How is it enacted? and how is it not enacted as well. I was listening to the news today, and this thing about the Israeli Knesset banning the UNESCO amounts to promulgating a law that outlaws international law, and I'm not sure how to deal with this, how to read this. I mean, is it possible to legislate outlawing international law? And does the institution do the institutions of international law have an answer to this? And my direct question is, okay, so these institutions are not acting fairly, so to speak. So it's easy to condemn Putin. It's not easy to condemn Netanyahu. We don't know yet. Maybe it's even impossible to condemn Netanyahu. It's not coming out the thing. And is there anything that one can do other than student protests and public protests and demonstrations, in cities and etc.? Is there anything that you can see that can be done in order to ameliorate or at least slightly fix the situation, etc.? Because what we've heard in the morning sessions today at the conference was to a good deal about the lack of trust in not only in the world order, which is untrustable actually, obviously, but also in the such laws, such tools as international law and human rights, etc., which at the level of jurisprudence probably have something in them that we should not sort of let go, but then we should think about how are we going to utilize them, and how can we sort of enforce them or force them to happen. Thank you.
I might have an answer for Amu Madar, if I can answer briefly.
Sure, go ahead.
In terms of what to do moving forward beyond just constant protesting, is at least within the West, the use of protesting has been too overplayed to the point where the government has just silenced us on the radio. And so it's not an effective form of action anymore. I think something that we have to do is adapt our techniques, realizing that what we're facing with is something much more heavier that can be dealt with just protesting as a response. Something such as an arms embargo, requiring a lot of people within different nation states to take advantage of their positionality in the world to stop ships holding weapons to go to Israel, or for example, crossing in the waters. That could be one approach that we can use, at least within the West. Something that is more tangible, effective, and quote unquote unliberal in a way. I think that is a way that the students and the community could come together to avoid this constant use of techniques, because it is getting overplayed, and we're noticing that these techniques have become not necessary as much as it was in the first year of the genocide. So now it's about amping up our strategies, diversifying, learning more from each other, and doing things that require more hands-on actions.
Thank you. I'm going to go a little bit out of order here, if that's okay, just because I think, Vasanti, you might be speaking to the same question. And then Gilchin, I saw that your hand is up, and in fact, Madar directed his question to you. So
yes, I was going. Yes, I was going actually to cede it to Vasanti, but
okay.
I want to probably make just a quick intervention, or maybe if you want, by way of a final reflection. Just to point out the obvious, that when we're speaking about the international community, that the international community is overwhelmingly in favor of the rights of the Palestinians. I mean, it has been in many General Assembly resolutions, Security Council resolutions, and support around the world. And the international community is not the US, Germany, UK, and Canada, right? Because they tend to see themselves as the international community, but that's not the case. So I think we should not forget this, actually, that Palestine has all of that support. Now, how does that translate into real support, right? And here I think there's a lot of work to be done, because the pressure on the governments is not going to come only from the students or from academic staff, but it has to come through political mobilization, right? So it's not only protests on the street, because we saw that protests on the street immediately changed the position of a number of governments, but you need to work also politically to put pressure on the governments to stop the arms exports, but also to actually put sanctions on Israel, since they have been violating international law now for more than 6 decades. So, and how do we achieve that? I think that was also the question of Mudar. How do we make sure that we implement these decisions by the ICJ and by the by the ICC and so on? And I think the implementation is by putting pressure on Western governments, because that is where the Palestinian issue actually has stalled and has been kept hostage for the last 57 years at least, because it has been very easy to condemn Israel for illegal annexations, denial of self-determination. But when Israel demolishes a EU-built school in occupied Palestinian territory, they get a condemnation, but they don't get Israel's revision of the agreement with the EU, or kicking out Israel from getting access to European Union research funds, right? So that shows that some of these states then, and we have to build on Belgium, Ireland, Spain, a lot of EU countries, others, to try to push for more. And if the EU stalls because there's a consensus rule there, then these countries have an obligation to go it alone. And a lot depends also on the US being the superpower. And I think probably a lot of what is happening, I will finish with that, a lot of what is happening, all of this tragedy that is befalling now, the Palestinian people has a little bit to do with the blank check given by President Biden, and the fact that Netanyahu sees that he's not going to be for too long in power. He sees it that international legal order and world order is changing, and a blank check from the US will not mean much or so much in the coming years. And he's trying to push for these mass atrocity crimes, including genocide, on the Palestinian people, while actually he, if you want, still can rely on that support. And that is the unfortunate thing, and that's what we need to push against.
Thank you. And Vasanti, the last word, I think, is yours.
Yeah, so I just want to say that so far we are thinking about international law as the ICC and the ICJ, a very state-centric approach. But the international law, in fact, a lot of international law is actually done by non-state actors. For example, corporations who are deciding on things, not just divestment, but all of trade policies and so on. And in fact, the push for why an arms embargo is not that straightforward is because of the pressure that corporations are putting on countries such as the UAE, Saudi Arabia, India, all of these countries who are voting in one system for Palestine, but on another system are entirely complicit in this process. So we have to think how the private sector or capital has managed to has managed to create all these leeways into it, but the people, the public, or if you think about mobilization, hasn't managed to make those very similar inroads that capital has made, that that the labor and the people can make. So I think we have to think innovatively outside of the box and outside of the ICC and the ICJ, even for an alternative global system, which on one side is happening through private parties, but the other side can also happen and is happening through community organizations.
Thank you. So let me take this opportunity now to thank all of our panelists and all of our
I
participants.
was wondering if you noted that there's one question in the Q&A.
Yes, so I've been texting with the person who asked the question, and he's presenting tomorrow, and we can address it tomorrow, unless you'd like to take it up now, Modar. I was just mindful of time.
No, you're the chair.
Okay, thank you. So I'll take the opportunity now to say thank you to all of the panelists and the participants. I really look forward to reading your papers, and I think the questions that you pose not only are about questions about how effective has international law been, or what tools can we invoke to make it effective, but I think one of the questions that I'll really look forward to reading about in your papers, if you end up getting to it, is the question not only of international law as a form of disincentive or sanction, but about the possibility of international law's capacity to address things like future harms, as was raised in the first panel in particular, and to live up to what's supposed to be its promise not only of addressing past harms, but preventing future harms as well. And so, if we had some skepticism about the smaller set of questions, the bigger question about prevention might bring about even more skepticism. But these are the moments in which we have to ask these big questions. So thank you again to all of you. And thank you to Mudar, to Joyce, to Mary, to all of the organizers of this panel and of the Mawatan 29th conference. Look forward to seeing you in person at the next conference, the 30th anniversary one. So,
Thank you very much.
yeah.
Bye.
Thank you. Bye-bye.
طارق أنا وقفت الريكوردينج. تمام.
ثواني أسير.
تمام.
ثواني أسير عشان أنا طلعت جاني حدا برا. هي أنا وقفت الريكوردينج من هون.
بس كمان على اليوتيوب وقف.
خليني أعمل هذا.